Hey everyone, Harry here to talk about the Supreme Court's decision to take up the immunity issue in the election interference case. All right, so the headline, it's always with Trump. You have to think of it in two different channels: the merits and the time, the delay, the all-important delay, the Trumpian strategy of delay and get this somehow not to be heard before the election. Because there's a lot of indication that if the case goes to trial and he's convicted, it would really affect, like nothing else, his electoral prospects, and B, because if he wins, on the other side of it, it's kind of easy pickings for him to basically make this federal case go away. So on those two channels, there's no reason to think, even though they're going to review the D.C. Circuit opinion, that they're going to hold for him or have some kind of crazy executive uber-alles opinion letting the president get a free pass for criminal conduct. That is not the risk and the disheartening aspect of what happened yesterday. Rather, it's the schedule. So you do the math, and they will hear the case in the week of April 22nd. That could have been condensed a lot more. This is sort of, point 3 here. When they want to expedite, they can do, and the DC Circuit, we've seen this as well, really expedite it to, very short turnaround times, which the litigants will just go with. Bush v. Gore being the prime example. We want your brief in 36 hours, the response in 24 hours. They gave Trump 3 weeks here. That's almost leisurely, given the overall stakes and their obvious recognition that we need some expedited treatment. But, they're going like in the third lane, whatever, where in Bush versus Gore, they careen like a fire truck up on the bank. So not super fast. And then, there's also in the not super fast category, 13 days to decide this. And a lot of people, myself included, thought that was a strong indication that somebody was writing a dissent, because how long does it take to actually just aggregate the votes? And in fact, it remains a mystery how, what exactly was going on behind the scenes. Maybe they were cobbling together little by little what turned out to be, might have only been 4, because the DC Circuit said if the Supreme Court takes the case, the stay remains, or it might have been 5. But is that what the 13 days were taking? But in any event, the point here is fast, expedited, but not warp speed. And anyway, so now you do the math. They hear the case April 22nd, the week of April 22nd, and there's only so much they can do to shave things down on the other side. An opinion must be written. It's possible that it be unanimous, but with this court, with this issue, with the Trump hovering in the background, that Sonia Sotomayor and Clarence Thomas will be on the same page. Kind of hard to see, and even if they are, it'll be after wrangling and negotiation by Roberts and the like, and that itself will take time. So the places to really cut back were before the argument is heard. Now it's got to be a month, it seems to me, and that would be pretty quick to prepare a majority opinion, have it circulate, have the dissents even pretty quickly prepare, go around, get it all ready, etc. So you got to count on at least that much. Now, let's say at pretty quick for what given that they have a fairly long windup. We get an opinion at the end of May, and it goes right back to Chutkan. Remember, we stopped the music in with a big chunk of the pretrial proceedings still to go forward, and Trump would have a very strong argument if Chutkan tried to say, "Oh, we need more time," and why? Everyone knows this is hovering out there, but they don't want to make it the actual reasoning because it seems to put their thumb on the scale. So if she said something like, "We really want to get this in by the election, and I'm going to shorten the time," he would have a pretty good due process claim, I think, that, you haven't given me all the time that I had coming to me just because you wanted to, shorten it. So we return to what's still a few months of the pretrial proceedings, and that's, if everything goes quickly. So we are looking at, it seems to me, at the earliest, August, mid to late August, and easily could be, early September. And there's a whole nother wrinkle here, which is the Supreme Court is hearing issue of whether or not there is immunity for official acts. If by chance they say sometimes there is, sometimes there isn't, we'd be looking at a remand. And I think, again, at the end of the day, shouldn't help Trump, because I think the courts would all hold, they have so far. Illinois pretty much just did it yesterday in a 14th Amendment case, that this was not within his official duties. So he would be losing, it wouldn't provide immunity anyway by this. It's a shorthand for like an amazing kind of display of anti-constitutional criminal conduct on his part in and around January 6th. So that, he doesn't escape for that reason. Why he escapes, if he escapes, it's all time, because to do that little part and to apply a Supreme Court holding, and then possibly does he get another appeal? Because it's still an immunity issue. We are at sort of zero margin for error, if that, because now let's say that everything from here on in goes, by the book and quickly, and we could start a trial around Labor Day. Man, that means that the a trial with the defendant, former president who's now running to be a future president, having to be in the chair every day in the middle of a presidential campaign, that is, in constitutional legal terms, funky in the extreme. It's just, there's no law against it, of course, because no one's ever contemplated. But this, now our best case scenario would be a trial kind of right in the middle. Now Chutkan has made it very clear, I don't care about the election. We're just going forward with what there is to be done. She theoretically could be saying, we're going to have trial even through the election, but it's it goes from momentous and singular to like really kind of crazy. And again, so how would that work? Some kind of mandamus for election interference and the courts having to weigh in. All of this is by way of saying that that on the all important axis of time, the court has really done a solid for Trump. We're now at a point where, at the very best, and that's if nothing else kind of slips, a trial could take place, but even so, it might not take place. And just to remind, this is the most important case. This is the one that really goes to the heart of his wickedness as president, and why, in fact, he deserves to be, never to darken the American political scene's door again. And yet, it looks like the reckoning here is going to have to be at the polls, and that's a problem. It's sort of you'll hear this talking point, but it's a little blithe because the fact is, seeing the case, seeing the evidence, and seeing a potential conviction really is completely intertwined with the question for voters about whether he should be the next president. So that it's going to mean a really incomplete kind of portfolio of information to put before the voters. And a lot of them, that they maybe will have had the Alvin Bragg trial. That seems unlikely to move the needle. And you have this, okay, funky in the extreme for him to be tried in the middle of the election homestretch. But how about this? Funky in the extreme for a likely insurrectionist, someone who betrayed the Constitution as severely as any president ever has, to become president again without the country's having had a reckoning about it. The impeachment, they said, well, he's out of office and the criminal process will take care of that. And here's the criminal process, but it's, he gets a series of breaks, the strong case in Mar-a-Lago, he draws his favorite judge, and that gets delayed. And by the way, even though he can't, if he wins the presidency, he can simply say, okay, you January 6th trial, you're done. I order you to stand down, and they have to. Can't do that in Fulton County, but Fulton County is a huge mess, and probably even in Fulton County, even if it weren't a huge mess, the courts would say it can't go forward when you are president. So we have this bizarre kind of series of concatenations and contingent events that break his way on the all-important scheduling point. And today we are at a much more remote possibility of going to trial in this all-important matter. I'll just mention this one from the beginning. Seemed like it really could go either way. I said, if you put a gun to my head, especially as the time dragged on, I would say they would deny and just let things go forward, and they were aware of the timing, but always a very strong argument, and the one that prevailed. And we'll see, but I'm not sure when. It might be, only in history, after a justice dies and 5 years thereafter get to see the papers, kind of what happened here. And if there was a fight on the court whether to take it or not. An interesting point to note is it's just not done really for someone to dissent from the grant of cert. You can dissent from the denial of a claim or a stay, but cert, four of the colleagues have voted to hear a case. What are you going to say? It's put in their discretion. But so we don't know exactly what drove them, and there's a lot of, I think, bitterness out there and conviction that they're in the tank for Trump, et cetera, et cetera. All I'll say is to that is the evidence is consistent with it, but it's quite a charge. And there's another way of looking at it, which is just, Roberts and another four at least were of the view that, huge question, never resolved. What the heck are we here for? What's the Supreme Court for if not to hear and resolve this? And that's what the basic broader institutional system requires. This is our job description, and we've just got to step up and do it, and not let ourselves be swayed by the timeline and its practical implications. And yet the timeline and its practical implications in this case And with all we know about what Trump has promised to do should he win, it's the really not hyperbolic to say that the vitality and maybe ongoing status of the American democratic experiment is on the line. Not that we become Russia the day after he is elected, but a giant step toward an autocratic state, a giant step toward smothering of the rule of law, a giant step toward a government that's just revenge and reprisal and lie after lie after lie after lie. Those are the stakes that I think the Supreme Court, blinded itself to, maybe thinking that's what they have to do. But in any event, the bottom line is they've, for whatever reason, so this is our ticket. See you in April, and pretty much ample time to write stuff. Something to be aware of is for the Jack Smith, the advocate will probably be a man named Michael Dreeben, who was a longtime member of the Solicitor General staff, very respected by the court, and is likely to really command their attention. And he's got the law, he's got huge tailwinds behind him. But again, the real risk here is not that they somehow hold for Trump, which I think has to be a long shot. And even if they do, under the question presented, Trump should still lose because it wasn't an official act. The risk, and it's the bigger one, it's become paramount, is time and schedule, and the distinct prospect now, far more distinct than yesterday, that this trial will not occur before the November 2024 election. Rough result, bad day. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.